We now move to the next case on our docket, the Florida Bar versus Herrera.
May it please the Court, Chief Justice, Justices, Counsel for the Florida Bar. My name is Herman RUSSOMANNO III, along with my co-counsel, my father, Herman RUSSOMANNO, who is behind me. We represent the respondent, Mr. Herrera, in this Florida Bar matter. I'd like to reserve 2 or 3 minutes for rebuttal. There's 3 issues that we want to address with the Court. The first issue is, under the Kane case law, the Bar not submitting its own work product to the referee. The second issue is, what is the appropriate sanction or penalty that should be imposed? It's Mr. Herrera's position that a 90 to 91 day suspension is more appropriate than a 10-year disbarment. The third issue is addressing several of the referee's underlying findings that we believe are clearly erroneous or lacking in support under the case law. Mr. Herrera, as the Court is aware, has been a member of good standing of the Bar for 33 years. He's never had a bar complaint until this particular case. He's never received any discipline. And what's important to note that there were several litigations going on at the time before Judge Thornton and before Judge Dresnick in the Bermudez case and the Tribe case. None of those judges ever found that Mr. Herrera violated any court order in a court order. None of those judges ever sanctioned Mr. Herrera. No motion for sanctions was ever filed against Mr. Herrera, 57, 105, or otherwise. And more importantly, no judge that was sitting in front of Mr. Herrera in either case reported him to the Florida Bar. The first issue I'd like to address is Mr. Herrera's position that the Florida Bar did not submit its own work product to the referee. The Bar freely admits, and counsel will admit when it's her turn to step up to the podium, and is confirmed in an email, that the complainant, Mr. Teen, was one of the complainants, participated in drafting the proposed report to the referee that was submitted at the end of the trial. And our position was largely adopted by the referee. And in fact, there were 2 drafts that were sent by Mr. Teen to Ms. Falcone's personal email address, which was not a Florida Bar email address, which we're aware is subject to broad public requests. And 50-plus pages twice was used ultimately, which is important under the analysis under the Kane case, which I'm going to address, by the referee in its ultimate report. Therefore, it's our position that the judge's ultimate findings and what was incorporated in 50 pages of findings and facts were used by the complainant and not the Bar's own work product. Of course, the Bar also worked on the document. No one's suggesting that they didn't. And under Kane, this Court has said recently, in 2016, this Court issued an opinion, and I'm quoting, "The Bar has an obligation to process cases in a fair and just manner." And the Court noted, and the Florida Bar Council even confirmed, and it's in the footnote of the opinion in Kane, Bar Council confirmed, and this Court made it a note in the opinion, that the Bar must and should submit its own work product to the referee. It's clear. And this was addressed years before we dealt with this case. In addition, and here's the distinction in Kane, at the trial court level, the Kane judge, the referee, Larry Stewart, lawyer in Miami, was involved in an affidavit, disregarded it, and found that the dismissal of that Bar case was inappropriate because Larry Stewart and the Bar's actions at the time did not lead to the ultimate recommendation by the referee. That's distinguishable from this case. Why? Because Mr. Teen's 50-page draft of the report ultimately ended up in the referee's, it was more than 50 pages, report. So we believe that not only Kane is instructive as to what the Bar should have done in this case and didn't do, but we also believe that it led to the ultimate findings report. And we believe that under Kane, the trial court or the referee judge at the time should either vacated the report or this court has the discretion to impose whatever order it does in terms of we're considering in the appropriate penalty. And the Kane case doesn't stand alone. There's a Willie Gary, a lawyer down in South Florida. There's a Gary case, and here's why I bring up the Gary case, because it's an uncontested case which I understand that the court approved, but here's the distinction. The complainants in the Willie Gary case were with Anheuser-Busch. They participated in drafting the complaint. And at that point, the referee judge said that one of those conducts with drafting the complaint was an additional reason why the case could have been dismissed. But here's the interesting issue. That was ultimately come up to this court. The bar did not oppose the referee's findings that the complainants, Anheuser-Busch lawyers, should not have participated in drafting that. If the bar took issue with that, they could have come up to this court, objected to it, filed briefs, but they didn't. It was an uncontested, and this court approved that order. This court didn't change anything in the referee's opinion in the Gary case. And Merle and Swickle, which are older cases, stand for the proposition it's improper to allow a private party to control and dictate the proceedings. It's our position that Mr. Teen, we're not speaking about Mr. Lewis, because he didn't draft it, Mr. Teen's participation, and it's undisputed, they were passing notes in the trial and preparing for witnesses is okay. I get that. But they reviewed the complaint. They drafted the proposed findings way beyond what bar counsel should have done herself, and according to this own court in Kane. In addition to the Kane issue, the discipline is what also the second issue we want to address. We believe the appropriate discipline in this case is 90 to 91 days and probation and not a 10-year disbarment, given Mr. Herrera's history.
Mr. RUSSOMANNO, before you go into that issue, can you address for me the issue of the Cook case? Because my understanding is that your client did not make a notice of appearance in that case, and in fact he was just monitoring that case. Can you address those facts for me?
You're correct. You're correct. And it's undisputed, bar will agree, Mr. Herrera never appeared in the Cook case. He was not subject to any of the sanctions by Judge Cook in the Cook case. He didn't do anything in the Cook case, other than there's an allegation that he sat in the back of a courtroom and took notes. The most I know is there's nothing wrong with sitting in the back of a courtroom and taking notes. And I don't think that's a bar violation. I don't think the bar is going to... So that's the answer to your question, Justice.
Thank you.
In regard to the discipline, the Brutus case, 2017, out of this court, the court's review of the discipline is broader than the underlying facts, and also the court's responsibility to order the appropriate discipline. And here we think the appropriate discipline, we think 10-year disbarment for not one judge in the underlying court sanctioning or no sanctions motions or filing is way beyond compared to what should be appropriate. No one's saying a punishment should not be made. 90 to 91 days, if you want to have rehabilitation, 91 days is what the position is, especially in the fact that Mr. Herrera did show remorse on the issue of filing a notice of judicial notice with Paul Cali. And he, from the beginning, admitted he shouldn't have done that. No one's coming before this court and saying it shouldn't have been done, and there should be a penalty imposed for it. In the Herrera case, which is an older case, and I know the court now has evolved since the Rothstein opinion, etc., the Herrera case says disbarment's an extreme measure. And back then, they used examples like embezzlement and bribery. Now we know trust violations are disbarment. And this is not the type of case like a Rothstein or like recently with a Jeremy Alters where there was $1 million taken from the trust account where disbarment was warranted by this court. This is not that case. And here's what I want to cite to one of the standards which I think is important. Standard 6.12 of the Florida Standards Opposing Sanctions. Suspension is appropriate when a lawyer knows that false statements or documents are being submitted to the court or the material information is improperly being withheld. Even with those findings, which some overlap what Judge Toon has found, in this case, suspension is the appropriate penalty and not disbarment. We're relying upon three main cases, Mr. Herrera's three main cases for 90 to 91 days. The McNamara case, 2013, is a recent case. The bar asked for disbarment. This court said no, 90 days is appropriate, and probation, which Mr. Herrera readily agrees to probation. And here's what that attorney did. That attorney lied to the IRS, that attorney filed a false petition to the probate court, and that attorney lied to the bar in questions. And then this court said recently, 2013, 90 days was appropriate. In addition, in 2005, the committee case, 90-day suspension on 5 rule violations. We're dealing with 6 or 7 in this case. That lawyer did even worse. Failed to comply with discovery requests, filed frivolous lawsuits, found to have abused the legal process, harassed another lawyer, received a Rule 11 sanction, held him in contempt of court and sentenced him to contempt 60 days in jail. That's what that lawyer did in the underlying cases, and a 90-day was imposed by this court. Mr. Herrera did far less than that. In addition, the Gwen opinion, this is the last case, the Gwen 2012, this court's opinion, a 91-day suspension, 7 rule violations. Mr. Herrera had 6 in this case, 6 separate rule violations. That attorney received a 91-day from this court recently for filing frivolous claims, harassing the opposing counsel, found to have willfully abused judicial system, filed false allegations in a pleading, false testimony before the court, found to be reckless, engaged in bad faith, sanctioned by the court, and the underlying trial judge correctly referred him to the Florida bar. That didn't happen here. So we respectfully submit that if this court looks back at McNamara, Committee, and Gwen, those are the binding cases, that this court should apply to Mr. Herrera, 90 to 91-day suspension. The 15 cases cited by the referee in her report, we went through both in the justices you'll see in our initial brief and our reply. Each one I painstakingly went through to distinguish to show that they don't apply to Mr. Herrera's case. Mitigation was proven. 6 or 8 character witnesses, former Judge Rosa Rodriguez, City Attorney Vicky Mendez, Ben Cuney testified on Mr. Herrera's behalf on mitigation. No prior discipline, remorse on Calais, and it also was going through some personal reasons, which his wife was diagnosed with cancer in October 2012, and then, thank God, at the end of 2014 was better. But the timeline here is 2012 to 2014, Mr. Herrera was dealing with his wife going through cancer at the time. That's also part of the mitigating factors. The last issue I want to address with the court is the referee's finding of a clear erroneous and lack of evidentiary support. The legal standard in Martucci, 1997, the bar is the high burden of proving by clear and convincing evidence. We know that. And here's this court's review of that. It'll be upheld unless it's clearly erroneous or lacking evidentiary support. This is under Martucci. And here's 2 examples of where the report makes findings that have no support whatsoever. There was an issue about a joint common defense interest agreement. The referee at pages 36 and 34 of her report says that the agreement did not exist. It's just not true. Here's the reason. Judge Leesfield, who's a well-seasoned circuit court judge down in Miami for many years, was appointed a special master at the trial court level. She, and this is tab 41, page 62 of an April 18th discovery hearing transcript. I'm specifically citing it for this purpose.
And where is that in the original record?
It's not in the original record.
Okay.
It's in the supplemental submission, tab 41 of the supplemental index.
What's the standard for seeking rehearing or reconsideration based on new evidence that was not presented to the finder of fact originally?
The standard is that it would be new evidence on the motion for rehearing, and it was not new evidence at the time. I would concede that point. However, it was understood that they had the underlying record. The bar had the underlying record.
Doesn't the standard include that the evidence, you have to have discovered the evidence after the trial, and you could not have reasonably discovered it before the trial with the exercise of due diligence?
That is the standard. I agree.
Did you try to meet that standard in asking the trial judge to consider on reconsideration the evidence that you're using to challenge her findings?
With that standard, no. It did not.
And she didn't grant that motion and consider that.
She didn't. But here's
so it's not part of the record that we can consider in determining whether the trial court's findings are supported, correct?
It's correct, but here's why that this court should, because it's true and it existed. Judge Leesfield stated on the record, I am holding in my hand the joint defense and common interest agreement signed by the parties Colley Billy, Herrera, Burt, and Rahman. This is the transcript by Judge Leesfield, who everyone in Miami respects as the judge in this case, in the underlying case. The fact that it existed and the fact that the complainant's team and their lawyer, Paul Calais, filed objections because he knew that that document existed, and the fact that it doesn't come out in the proceeding, and it could have been filed earlier. I agree, Justice Lawson. I agree with you. The fact of the matter is it existed, and it should have been corrected under Bokerberger the court or counsel could have corrected under Bokerberger that said, that's the reason why it should be in the record. In addition to the...
Counsel, you're about to exhaust all your time. Now, you can keep going, but you're not going to have rebuttal.
30 more seconds, and then I'll...
Okay, what I'll do, you sum up quickly now, and I'll give you an extra minute for rebuttal.
In addition, the records custodian affidavit, same thing. Judge Leesfield said that that document was of the records custodian and Jimmy Bird, and I'll save a little bit of time for rebuttal. Thank you.
Good morning, Your Honors, if it please the court. Just first to address to the excuse me, I'm very sorry. The bar, as Respondent's Counsel acknowledged, never tried to attempt the complainant's participation in the drafting of the report of referee. It's because it's the bar's position that nothing in the Kane decision or any of the cases that came before it prohibit that kind of participation. There's no evidence here that he was participating in directing, controlling, or managing the prosecution of the case. He didn't direct the investigation at the grievance committee level. He didn't draft the complaint, which is the charging document, which would be shaping the way the bar was prosecuting the case. He didn't put the evidence on himself. The bar did all of that. The bar presented an entire case before the referee. 5 days of testimony, thousands of pages of document, and 59 exhibits presented to the referee. What the complainant did was basically recount for the court what had happened at the trial in the case. He wasn't creating new evidence.
Well,
he wasn't directing.
let me ask you a question. In the referee's findings, there is a position taken that says that over 6 years of litigation in 3 distinct state and federal trial courts, the positions espoused by respondent were found to be wholly frivolous and without any legal merit. How can Mr. Herrera espouse positions in the Cook case when he never made a notice of appearance?
Your Honor is accurate. The bar has never argued that he should be found guilty of anything having to do with the Cook case. The referee's discussion of the Cook case came about when she was questioning the respondent. He had testified what he was doing, why he was there. She asked him who he billed. He said he billed the tribe, and then he tried to convince her that he was actually there to represent Bert when Bert had no interest in the case. The only relevancy to the Cook case for any of the factual findings or rule violations in the case comes from the referee making a determination that he basically misrepresented those facts to her during the trial testimony. It wasn't because of something of his participation in the Cook case. Getting back to the Kane decision, this is at the end of the prosecution. This isn't controlling, directing, or doing anything to take over bar counsel's role in prosecuting this matter. Additionally, it's merely proposed findings. Bar counsel received the draft. Bar counsel reviewed every single line. Bar counsel made changes where changes were necessary or appropriate. The referee did the same thing. She looked at the findings of fact. Every one of them was backed up to citations in the record or exhibits in the record, and the referee made those same findings based on the citations in the record and the exhibits in the record and her own view of what happened at the final hearing. There is nothing in Kane. Kane was about the bar and complainant being complicit in drafting what was alleged to be a perjurious affidavit that was supposed to be used as evidence in the case. There was evidence that they misrepresented that at a deposition, and there was evidence that the complainant actually controlled the prosecution in the case, multiple emails directing the prosecution of what to do. There is nothing like that in this case. There's nothing even remotely analogous. There's not even anything remotely alleged. It's basically a red herring, Your Honors. Getting to the sanction argument, this is extremely serious misconduct. What respondent's argument has completely ignored is the findings by the referee that the respondent made misrepresentations, misled the courts at all levels of this matter, including the underlying cases and the referee matter. He ignores the suborning of perjury.
Before you continue that, I'd like to go to paragraph 68 of the referee's findings. It says, while respondent did not enter an appearance in the federal case, he attended days of those federal hearings and billed the tribe for his time. I would like to know whether or not it's going to be the bar's position going from this date forward that any attorney who goes and watches a case where a client could have a potential matter involving the case, are they going to be now on the hook for potential bar discipline?
Absolutely not, Your Honor. And the referee actually made that clear.
And then it goes on to say, by any plausible stretch, nothing in those hearings remotely concerned whether Burt was liable for the Bermuda's wrongful death. That may be true, but you have an obligation to a client if there is something going on with respect to that client and that client is being discussed, correct?
Yes, I would agree with that, Your Honor. And the referee stated over and over and over again in the record, she had no problem with it's a public forum, anybody can come in, anybody can watch for any purpose. She had no issue with that. What she took issue with was the misrepresentation respondent made to her about who was paying her and why he was there.
Okay, that's not clear in the referee's findings, but okay.
It is in the record, Your Honor. Those statements are explicitly appear in the face of the record transcripts.
Well, not in the case, not in the findings.
I understand.
Okay, which is what I'm looking at. Thank you.
Going back to the sanction, extremely serious misconduct. He ignores the findings about suborning perjury. He ignores and the misconduct occurring into the disciplinary process. The referee actually made very scathing findings, and I'd like to just read some of them into the court because they justify the enhanced sanction in this case. The positions still espoused by the respondent were found to be wholly frivolous and without any legal merit, and yet respondent continued to make them in the disciplinary action. At page 61, respondent continued to espouse positions in contravention of all previous court rulings. The evidence available shows he did so in a knowing and intentional manner with utter disregard for the consequences of his conduct to all parties. And the consequences were severe. He litigated this case in a manner completely inconsistent with his own client's interests and actually harmed and prejudiced his client in many ways before the IRS and made him responsible for imputation of income that he was now responsible for, taxes on, penalties, interest, going all the way back to the beginning of this matter, which was all unnecessary because it was untrue. The position that he was espousing was clearly and demonstratively not true. The family was always paying back the fees, and the fees for Mr. Burt, whether or not he stopped making disbursements himself, his fees, his services were still being added to the total of the loan. Respondent knew that. He had the invoices and he had the spreadsheets that showed the balance going up based on those invoices, including Burt's services, and he had the distribution report showing the amounts being paid down by himself or by the family. Doesn't matter, it's still a loan. It was a complete and total mischaracterization of the evidence and misrepresentation to the court by omission. Excuse me. Because of that, his own client was severely harmed, and that is absolutely appalling and takes this case to an entirely different level than any other cases that have been cited for the sanction in this matter, and the referee found that to be completely appalling. She was also appalled by his misconduct continuing into even the sanction phase hearing, where she accused him essentially of creating a kangaroo court situation because even after everything that had been said and done, he still was withholding evidence and popped up with the alleged joint defense agreement after all the evidence was in, after all the hearings had been done, after all the arguments had been made. Because of these actions, the referee found that his conduct indicated an inability to be rehabilitated. And I think paragraph 72 is probably the most instructive regarding her view of the case. This case does not present an isolated incident of misconduct. Thus, an extraordinary importance of respondents' repeated actions over a period of years, up to and including the disciplinary and sanction hearings. Moreover, the evidence in this disciplinary case shockingly shows that respondent did not merely fail to act in the best interest of his client, Mr. Burt, but affirmatively litigated in a manner in contravention to his client's best interest and the mute as post-judgment collection proceedings. On a personal note, this court has struggled greatly with the ultimate recommendation as to sanction, but believes the facts of this case, cumulative acts of misconduct, and applicable law support the findings herein. She cites to several of the cases talking about suborning perjury and presenting false evidence to the court, and they all say disbarment is the appropriate sanction. Like I said, here he did it basically to the harm of his own client, and he continued those actions, and that requires the enhanced sanction that the referee recommended. Your Honor, I can go through the case law. Primarily responsible, Agar, the client was disbarred, the respondent was disbarred after allowing a wife in a divorce case to testify under a false name and give false evidence as to how she knew the husband. He was disbarred even though the testimony was that it wasn't his idea and it was on a minor issue. Here, even where those kind of mitigating factors are present, we don't have any of that in this case. These were not minor issues. This was the heart of the case, and it resulted in great harm. We have the Dodd case, which of course is rather old, but stands for the proposition that, again, disbarment is the appropriate sanction where you have a respondent presenting and suborning perjury and perjurious testimony to the court. The Hymalowski case, and I'm sure I'm butchering the name and I apologize in advance to anybody about that, but there was a 3-year suspension for a sort of similar misconduct in that case. However, the court in that case said it would have been disbarment. The only thing that saved the respondent from disbarment was the referee's finding of no dishonest or selfish motive and good character. Here, the entire proceeding was dishonest and selfish motives based on the malicious prosecution that respondent was aiding and abetting. But in addition to that, the referee specifically limited the character evidence. She accepted it, she took it in, but she said it was inconsistent with her view, with her observations of the respondent during the final hearing in our case. And therefore, she didn't accept it with the same degree that some of the other courts have in these cases. Your honors have stated over and over again, cumulative and similar misconduct has to be punished more harshly. You've stated that similar acts of misconduct in the same proceeding, even when there's no prior discipline, can still warrant disbarment. You've also said that disbarment is appropriate even where the exact same facts haven't resulted in a disbarment opinion before. And we'd ask the court to adopt the report of referee, and perhaps with the removal of the one Cook paragraph that Justice LAGOA was talking about, but adopted in its entirety in the factual findings and conclusions of guilt, as well as the recommended sanction. Happy to answer any questions.
Counsel, if I can just ask 1 or 2 questions on the Cook matter. So as I understand it, during the course of testimony, the respondent testified that he attended the Cook trial, he was not a participant in it, he did not file a notice of appearance, but that he was there to represent the interests of his client, correct?
Yes.
And then the court questioned him, the referee questioned him.
Yes.
And during that questioning, it turned out that, in fact, he was not billing Mr. Billy, his client, he was in fact billing the tribe at that time, correct?
That's correct.
And then on page 107 of the trial court, of the referee's recommendation, she wrote, finally, upon questioning by this court, respondent admitted he billed the tribe, and she underlines the tribe, for attending the Cook hearings in the federal case, while at the same time trying to convince the court, the referee, that he was there to represent Burt and not to work, quote unquote, below the radar for the tribe in the Cook case. Respondent misrepresented to the court, and then deals with another statement. So the issue there wasn't his participation in it, it was the misrepresentation that was being made to the referee.
Exactly. And again, the referee stated over and over again, anybody can go and watch and, do whatever they want in the courtroom. It was the fact that he billed the tribe, first said he was there for his client, then admitted he billed the tribe, and then still tried to say, even though he was billing the tribe, he was there on Burt's behalf, which she found to be inconsistent and incredible.
And then the referee used that misrepresentation as aggravation for the penalty that she ultimately recommended, correct?
Yes, Your Honor.
Okay.
She actually found the respondent's testimony throughout the final hearing to be completely incredulous, completely rejected that testimony, applied her common sense as she is permitted to do by your case law in order to make those findings, and discounted most of the evidence respondent provided.
Is the bar asking for anything beyond the disbarment with the 10-year bar to reapply?
No, Your Honor.
Okay. And the bar sees this as different than a permanent disbarment, as some other participants in this case received.
Yes, Mr. Bernie Roman was in fact the ringleader in this case. It was clear through the evidence he was calling the shots, and his conduct was warranted a permanent disbarment and also continued into the disciplinary process.
But the bar does not believe that's the case here.
The bar is satisfied with the referee's recommendations.
Yeah. Thank you.
Very briefly.
I'm sorry to interrupt you. Could you just take a second to respond to what opposing counsel said about the harm to the client here, and sort of what your overall response to that is in the context of us helping us figure out what the appropriate penalty should be?
The harm, it's our position there was no harm done to the clients. He was defending Mr. Burt. There was no collection against Mr. Burt. There was an issue as to whether the tribe was paying or whether there were deductions being made. And this whole thing started with Mr. Roman, which counsel stated, where Mr. Roman handed plaintiff's counsel 61 checks from the tribe to pay Lewis and Teen's legal fees. That's how it started. So it's our position there was no harm done by Mr. Herrera to Mr. Burt, his client. And he did represent the tribe, and that's the reason why, Justice Luck, he represented the tribe in the Thornton case. So there was a reason for that. And I just want to end with 2 points, 30 seconds. I wrote down red herring. Counsel said the Kane issue is a red herring. Using a personal email that's not from the Florida Bar's email is not a red herring. Having the complainant draft 50-page drafts of the proposed report, which ultimately got into the judge's ultimate finding, is not a red herring. The bar and Kane is important because this court, in its own opinion, recently said the bar must and should submit its own work product. That did not happen here. It was Mr. Teen's work product. And lastly, on the suspension, we respectfully submit 90 to 91 days as the appropriate penalty under McNamara, Committee, and Gwynn. Mr. Herrera had a clean record, 33 years, and he was never sanctioned or found in any violation of a court order in any of the underlying litigation in regard to this bar complaint. Thank you for your time.
Thank you. We thank you both for your arguments.